Thank you, David, for that very generous introduction. Let me begin by congratulating all of you on your admission to the JD program, to a university law school that is a remarkable place for the reasons that David has already articulated for you, and I think that your experience here will undoubtedly be very rich and rewarding for you, and also rich and rewarding for those who will have the privilege of teaching you. David has mentioned what an extraordinarily diverse group you are, and I won't go through some of the matters that he has mentioned, but one feature did strike me as significant. Your ages apparently range from 21 to 72, and I want to congratulate the 72-year-old on his or her optimism. Not something that at this stage of life I necessarily share, but it's also a blow, I think, against compulsory retiring ages, so I encourage all 72-year-olds to seek admission to law schools in this country. Now, you'll probably be relieved to hear that I don't intend to recount all the remarkable changes that have occurred since I set foot on this campus almost exactly 43 years ago. I won't go over the history of the teaching in the fabled temporary huts, about which you will hear much in the course of your law school experience here, not very far from this part of the campus. I won't go over the subsequent emergence of the law school as a national and international leader in legal education, that you already know about. I won't go over the increasing diversity of Australian society over the last 4 decades, the astonishingly rapid transformation in the role played by women in this society, exemplified by 3 women being on the High Court of Australia. The recognition, however incomplete, of the injustices done to the Indigenous people since European settlement, the pervasive influence of economics on political thinking and public policy, the impact of globalisation on commerce, employment opportunities, social behaviour, and education, which explains why there are so many of you from other countries who have joined this course, the emergence of hundreds of millions of people from poverty in Australia and elsewhere in the world, the phenomenal technological advances that have profoundly affected not only the law but our daily lives, the impact of a developing international human rights regime on domestic laws in so many countries. If you want evidence as to how things have changed so dramatically over the period I'm talking about, just go outside, and if you go to the left, you'll see a photograph of me taken about 1978 when I was Dean. Compare that with what you see now and you will understand what I mean about dramatic changes. But I'm not going to talk about any of these things. You know all of that, otherwise you wouldn't be here. What I am going to talk about is the rule of law and what it means for lawyers, and what I hope in any event it will mean for you. I appreciate that not all of you will necessarily work within the legal community in your careers, whether in this or another country. But your experience at this law school will inevitably influence your attitudes towards broader social, legal and political issues, whether in Australia or elsewhere. And I think this is particularly true for those of you, and perhaps you won't think of it this way, but there are many of you who will come to occupy leadership roles in your chosen fields. One of the features of a legal education is that so many who have the privilege of such an education go on to leadership roles, whether in the political field, commercial field, legal fields or elsewhere. James Madison was the 4th President of the United States, and he, as you know, is generally regarded as the author of the United States Constitution and of the Bill of Rights, the first 10 amendments to that Constitution added in 1791. Like many of the founders of the United States Constitution, Madison was a slave owner, and he was profoundly sceptical about the virtues of democracy, at least as he understood the concept. Writing for a newspaper under the name Publius, and the article to which I am referring comes down to us as number 10 in the famous Federalist Papers, that were papers published around the time the United States Constitution was being debated. In the paper number 10, he lamented that a pure democracy, by which he meant a small body of citizens who administer the government in person on the model of an ancient Greek city, in his words, can admit of no cure for the mischiefs of faction. He said that the common passion of the majority would have no compunction about sacrificing the weaker party, by which he meant minorities, or sacrificing obnoxious individuals. And it was for that reason that Madison thought that these democracies, that is, direct democracies of the ancient Greek kind, have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and as a slave owner he was very much concerned with the rights of property, and have in general been as short in their lives as they have been violent in their deaths. Madison had an answer to what he saw as a problem, the problem of the defects of direct democracy, and that was the establishment of a republic under which a body of citizens would be chosen who, in his words, whose wisdom would discern the true interest of their country and whose patriotism and love of justice would be least likely to sacrifice it to temporary or partial consideration. Madison recognised the dangers of inappropriate choices by the electors because of prejudice, intrigue and corruption. But he thought that these risks would be minimised if the republic was larger rather than smaller. And the more numerous the electorate, the more likely the selection, again in his words, of men who possess the most attractive merit, much like Madison himself. The snobbery and fear of the demos, the people, held by some of the founders of the American Constitution, are no longer fashionable. It's difficult to imagine a 21st century Australian politician, for example, questioning the good sense of the Australian people, even if he or she is planning at that very moment to circumvent popular opinion at the first opportunity. And Madison's analysis was undoubtedly defective in a number of respects, including historical respects. But in retrospect, he had a point. Now, with so many concepts that play an important role in our political and legal discourse, democracy is capable of many different meanings, and it can take many different forms. These are explored from an historical perspective by John Keane, now an academic at the University of Sydney, in his book called The Life and Death of Democracy. But the point can be made in contemporary terms by comparing the very different democratic institutions in Australia and New Zealand. I was much relieved to hear that there is actually a representative of New Zealand here. I couldn't possibly contemplate a course at a law school in this country without a New Zealand representative. But just think of the differences. A unicameral system in New Zealand, a bicameral system of the federal parliament in Australia, the existence of a statutory Bill of Rights in New Zealand, no such equivalent here. Very different electoral systems in New Zealand, multi-member proportional systems. In Australia, this melange of electoral systems that just the other day led to the High Court in its capacity of the Court of Disputed Returns overturning the Senate election in Western Australia. And when you look at the composition of the Senate in Australia that will take effect from the 1st of July this year, you wonder how the human mind is capable of producing an electoral system with that result. Perhaps some of you from other countries might like to have a look at it and marvel. So there are very great differences between countries that are plainly democracies like New Zealand and Australia, reflecting very different systems within that broad concept. But one view of democracy is what one commentator calls the thin conception of democracy. By that, the term simply means that the legitimacy of government is conferred by and with the consent of the people, which translates into the consent of the majority of the people. And this majoritarian concept of democracy leaves a whole lot of questions unanswered, including the mechanisms for ascertaining the will of the people, the composition of the electorate, and the precise nature of representative institutions. But it implies that the essence of democracy is the election of the government by and in conformity with the wishes of the majority of the people. In scholarly and political discourse, the notion of democracy is very closely associated with the rule of law, which of course is where law schools and law students come in. But it's not at all difficult to conceive of a democracy in the thin sense, the sense of a majoritarian democracy only, that lacks basic elements of the rule of law. The government of a particular country, a particular political entity, might have the support of a majority of the people, even an overwhelming majority of the people, manifested in free or relatively free elections. And yet that same country or political entity might subject minority ethnic, religious or political groups to serious discrimination, if not outright persecution. Minorities might be denied, for example, the freedom to pursue their religious, cultural or linguistic heritages, or they might be deprived of basic services that the majority take for granted. Dissenters within those communities charged with criminal offences might be denied the protection of a fair trial before an independent and impartial judiciary, and arbitrary imprisonment can be a weapon of state control. Putin's Russia is probably an example of this phenomenon. Relatively free elections supported by a majority of the population in all probability, but not a country that respects human rights or the rule of law in a number of important respects. I notice that there is someone here from Pakistan, and I think unhappily Pakistan in the not too distant past provides another example, for example in 2007 when the Chief Justice of that country was dismissed. There is someone here from Iran. Iran might fall into that category as well, although perhaps that's debatable, in part because the elections in that country, however vigorously contested, may not be described as free when the Guardian Council disqualified 678 out of 686 candidates for the presidency in the last election. And in case we're ever tempted, or you're ever tempted, to overstate the guarantees that are inherent, the guarantees of freedom that are inherent in a democracy, it's worth remembering that when Hitler came to power in Germany in January the 30th, 1933, his ascent to power was preceded by the electoral victory of the Nazis in 1932. They didn't secure a majority of votes in the election that year in Germany, but they did obtain the highest proportion of votes. The Nazis got about 37% of the popular vote, which was greater than the combined total of the next two parties, the Communist Party and the Social Democrats. Hitler came to power within the structure of a genuinely democratic electoral system in a majoritarian sense. Now, you may be thinking, what's he on about? This is all exceedingly theoretical. They're not. These observations are not. We don't have to look very far in a geographic or temporal sense to detect other democracies flouting the rule of law. As most of you will be aware, in January this year, the President of Nauru dismissed that country's resident magistrate. When the Chief Justice of Nauru, an Australian resident and former judge of the Supreme Court of Victoria, issued an injunction restraining the magistrate's deportation from Nauru, the government simply ignored the injunction and cancelled the visa of the Chief Justice. The justification for this extraordinary conduct was said to be that the government had lost confidence in the magistrate, citing unparticularised and unproven allegations of inappropriate conduct. The President of Nauru survived a no-confidence vote in what I assume is the democratically elected Parliament of Nauru, thereby demonstrating that democracy is no guarantee that the rule of law will be maintained. Why does this matter to us? Well, it does matter to us quite considerably. Many organisations and individuals in this country and elsewhere have criticised Nauru's actions as a fundamental departure from the rule of law, which it surely is. The Australian government has said that it does not intend to engage in megaphone diplomacy, but has communicated its concerns to the Nauru government. Given Nauru's pivotal role in Australia's efforts to stop asylum seekers arriving by boat, because under our current system, arrivals are sent to Nauru for processing and repatriation or resettlement as the case may be, the episode indicates how a failure to adhere to the rule of law in one country, in this case a microstate central to Australia's so-called border protection policies, can have direct consequences for another country, in this case Australia, which has effectively outsourced its obligations under the Refugees Convention to Nauru, among others. Recent events in Manus Island, or on Manus Island in Papua New Guinea, have not yet been elucidated by the official inquiries that are apparently underway, but there is at least a possibility that they also raise significant rule of law issues that have a direct impact on people for whom Australia has responsibilities under international and domestic law. In case you think this is an isolated phenomenon, remember that even the great Western democracies cannot claim an exemplary record on adherence to the rule of law. That bastion of democracy, the United States, has a very patchy rule of law history. One of the great biographies is by Robert Caro of Lyndon Johnson. The third volume of that Lyndon Johnson, The Master of Senate, is one of the most remarkable political biographies, if not the most remarkable political biography I have ever read. It analyses in painful and anger-inducing detail how a minority of racist Southern senators were able to forestall for decades the most basic federal civil rights legislation in the United States, even bills which would have provided some measure of protection to the black population against lynching. If you want a more recent example, Guantanamo Bay will do. The Australian White Australia policy, one of the foundations of settlement in this country, may not have led to lynching, but it was hardly a shining example of the rule of law in action. And the White Australia policy was only abandoned relatively recently, not long, formally speaking, after I came to this law school. Now, just as democracy doesn't have a universally accepted definition, so there is disagreement about the essential elements of the rule of law. The core idea, however, is that all members of the community are entitled to certain basic protections from the legal and political systems. The most fundamental of these, but not the only one, and certainly not the only one, is that the rights and obligations of citizens must be set down in laws that are formulated by a genuinely representative legislative body or other authorised organs of the state, like the courts, or administrative agencies acting pursuant to statutory power in accordance with established procedures governing lawmaking. To that extent, obviously, democracy and the rule of law overlap. But adherence to this core concept of the rule of law, just like adherence to the thin concept of democracy, is not sufficient to ensure compliance with rule of law in its fullest sense, and is not sufficient to ensure that rights and freedoms are protected in an appropriate way by the legal system. The reason is pretty obvious. Oppressive regimes may scrupulously observe or appear to observe legal forms and yet deny fundamental freedoms to significant components of the population. One only has to think of apartheid South Africa, where the majority of the population was, of course, oppressed, or even Stalin show trials, characterised as they were by apparently full and free confessions of heinous wrongdoing by those who were destined to be shot within hours of the public performance. Neither South Africa nor Russia or the Soviet Union was a democracy even in the thin sense, despite their pretensions, but they did claim to observe the rule of law. For this reason, it's generally accepted, and no doubt this will be explored in a number of your courses in the law school, that a legal system cannot satisfy the minimum standards required by the rule of law unless it incorporates many other protections. These include a requirement that those in authority exercise power within constraining and predictable public norms, rather than on the basis of the preferences, ideology or sense of right and wrong of particular administrators or representatives of the state. A second element widely thought to be essential is the existence of an independent and impartial and therefore incorruptible judiciary which applies legal rules and principles that have been formulated in the manner that I have described. A third requirement, and this is developed by legal philosopher Jeremy Waldron, whom you will come across, or many of you will come across, a third requirement is the right of all persons to a fair hearing, whether of a civil claim or in a criminal prosecution, in accordance with principles of open justice. The notion of procedural fairness is fundamental to the rule of law, and it has become an integral part of the Australian legal system, entrenched constitutionally, and it is an area where the quintessential role of protecting procedural fairness is played by lawyers, much to the frustration of other decision makers, but it is done because of the importance of the rule of law. There are other principles that are arguably part of the rule of law, and I won't go through them in detail, but they include the principle of equality before the law, meaning that all like cases should be treated alike as far as practicable. Unequal treatment should be justified by objective differences in the circumstances of each case, enforceable prohibitions on arbitrary arrest and detention, and so on and so forth. There's room for lots of disagreement about the precise scope of the rule of law, but I think you get the idea of the core concept and the penumbra, if you like, beyond that core that is essential if basic freedoms are to be protected. Now, how does all of this relate to you? those of you, and you are, entering law school and undertaking legal education, and many of you, no doubt, contemplating a legal career. A core function of lawyers in this country, and in any other legal system professing adherence to the rule of law, is to preserve and maintain the rule of law. And one consequence of that function that is important, I think, that you appreciate at the outset, is that lawyers cannot expect to win popularity contests. That is, unless they change careers. Becoming a merchant banker won't do the trick, but turning into a comedian or popular novelist does sometimes work. But the job of a lawyer doesn't necessarily, and indeed often cannot, involve seeking popularity or gaining popularity. Why is that so? The rule of law requires the rights and freedoms of minorities to be protected. What David said in his introduction demonstrates that proposition. It follows that lawyers and courts are often in the business of representing or determining the rights of the poor, the marginalised, and in Madison's phrase, the obnoxious. Who are the obnoxious people? Well, there is an obvious category. The most obvious example of obnoxious people, at least as perceived in the broader community, is of course people charged with particularly heinous criminal offences, particularly those that attract the attention of what politely can be called the mass media. Public opinion can be a very powerful force, but the passions aroused are not always for the good, as some of the American framers of the Constitution understood, and are peculiarly susceptible to manipulation in an age of instant communication and attention-limited spans. Of course, you don't have limited attention spans, but lots of other people do. Community revulsion at certain kinds of criminal conduct means that a lawyer responsible for defending an accused person can rarely expect community gratitude. Sometimes the lawyer gets it. That happens when the criminal concern becomes the subject of a racy mini-series. But apart from that, the answer is no, you can't expect popularity. And courts are often placed in an even more difficult position. The revulsion against some of those convicted of serious offences is the principal reason why sentencing decisions are so frequently described as inadequate and judges are said to be out of touch with community standards. It's not at all difficult to attract the wrath of populist commentators and of politicians, all too willing to propose or to adopt simplistic solutions to complex social problems. The relationship between courts in particular and governments can be uneasy for other reasons, most notably because the judicial function necessarily involves courts acting in what can be described as a counter-majoritarian manner. In part, this follows from the role of the High Court, like the Supreme Court of the United States or the Supreme Court of Canada, although not the Supreme Court of New Zealand, where there is a written constitution and the court has power to declare legislation invalid on the ground that it contravenes the constitution as properly interpreted by the courts. It's been the case in the United States since the famous case of Marbury Madison in 1803 that the courts are the final determiners of the meaning of the Constitution. In Australia, it has been axiomatic since Federation in 1901 that the courts perform that role. It follows that if courts can declare legislation invalid, they must have the power by their decisions to frustrate the will of democratically elected legislatures and governments, sometimes with profound political consequences. In Australia, in 1948, the High Court decided the bank nationalisation case, which invalidated the bank nationalisation legislation of the Labor government, which was a central platform of its economic socialist policy at that time. In 1951, to prove its bipartisan credentials, the High Court invalidated the Communist Party legislation that banned the Communist Party and was a central plank in those McCarthyist days of the incoming Conservative government. Both of those decisions were of profound political importance and affected the political system for many, many years, and in some senses still do. In recent times, the High Court of Australia, despite something of a reputation for greater judicial restraint than was once the case, has shown itself willing to expand the scope of judicial review, often in order to preserve rule of law and democratic values. And so here we get into areas like the implied freedom of political communication that has been detected in the Australian Constitution, and the jurisprudence associated with Chapter 3 of the Constitution, with which you will become intimately familiar because it deals with the judicial power of the Commonwealth, and the High Court has used that in order to import what I call a truncated Bill of Rights into the Australian Constitution, and that jurisprudence, for example, prevents parliaments from conferring on courts functions that are deemed by the High Court to be incompatible with the essential nature of a court. So Parliament cannot require courts, for example, to act in a procedurally unfair way that would be inconsistent with their integrity as judicial institutions. This counter-majoritarian function is not limited to constitutional adjudication. Even the statutory interpretation, which is the function of the courts, can have that effect. Think about the Malaysian solution to border protection proposed by the previous Labor government. The High Court in 2011, in the Malaysian Declaration case, effectively put an end to the Malaysian solution, which was a key component of the government's offshore processing policy at the time. The High Court held that the declaration of Malaysia as a country to which asylum seekers could be transferred had not been made in compliance with the requirements of the Migration Act and was therefore invalid. Of course, it was open to Parliament because this wasn't a constitutional case. This was just a case about statutory interpretation. It was open to Parliament to amend the legislation so that Malaysia could be validly declared, and Parliament in fact did that. But the Malaysian solution was never revived, demonstrating that these decisions may have an impact beyond the particular issue that arose in the case. Now, as I've said, I know that not all of you intend or will necessarily embark on or pursue a conventional legal career. These days, the law degree opens up doors to all manner of careers beyond the traditional paths followed by legal practitioners, at least in this country. Barristers, solicitors, legal academics, corporate lawyers, government lawyers, international lawyers, and so forth. But whatever path you follow, as long as legal skills are required, and they are required or a great advantage in many areas other than traditional legal practice, there are some fundamental prerequisites for success. Sir Gerard Brennan, one of the great figures in Australia's judicial history, at the time he was a justice, later became Chief Justice of the High Court of Australia, identified four essential requirements for success as a lawyer. Legal competence of a high order, fairly obvious, a willingness to serve the community, professional commitment going well beyond the call of strict duty. One of the things that lawyers do actually is work very hard. And of course, personal integrity. Now, those four elements of a lawyer's makeup are, I think most people would agree, essential. But I would add a fifth attribute that follows on from what I have been saying, and I think is of direct relevance to you in your studies and in your future careers. And it's an attribute that is of particular significance for those who see their function as including the maintenance and protection of the rule of law. And that attribute is courage in representing the interests of poor and disadvantaged groups and individuals, and stoicism in the face of criticism and even denigration. I don't want to exaggerate. In this country, lawyers are not generally threatened with incarceration or torture for doing their job, although occasionally they might find themselves subject to searches under warrant. Judges enjoy security of tenure and other guarantees of their independence, so we don't fear dismissal, unless we do something really awful, or physical retribution for unpopular decisions. But even so, for the reasons that I've tried to articulate, performing the core functions of a lawyer or a judge in a democratic system that respects the rule of law is not always easy, but it is of profound importance, and it is ultimately the most rewarding thing that you can do as a lawyer. I wish you well in your studies, and I wish you well in your chosen careers, whatever they may be. Thank you.